such a breadth of an area. But if we could maybe in just a few moments we have remaining, final thoughts from each of you, any final closing remarks you'd like to share with our attendees, maybe just one key point. And I actually want to start with Minh here. Any final closing remark you'd like to share?
Sure, thank you. My closing remarks would be that there are numerous potential remedies that may be available in a theft of trade secret case that includes a violation of one or more restrictive covenants. It is an important consideration for the court is that an analysis by the economic expert should add value beyond merely presenting figures directly from the parties in suit. The economic expert should present a concrete calculation of the appropriate remedy where the inputs and assumptions underlying the calculations are tied to the facts and circumstances of the case.
Thank you so much. Ron, thoughts from you?
Sure. I think it's always best for the company to spend a few minutes or more than a few minutes thinking about these non-disclosure, non-compete agreements, because again, too often people are using a form and not really looking at their own business and what's suitable for their business, because that's what the court's going to look at ultimately if you need to enforce it. So that you need to look at it with that in mind.
Thank you so much. And Avi, any final thoughts from you before we wrap up today?
Yes, I think if you have trade secrets or other assets to protect, there are really a number of very powerful, effective tools that you can rely on. I agree with Ron. If you take a careful look at your agreements, the agreements can constitute a significant means of protection, and the statutes, the DTSA and the UTSA, provide very powerful relief. And the trend of the last 10 years or so has been that the verdicts in this area have been huge and have been a real disincentive against misappropriation. So if you have a problem, it's worth analyzing and considering these remedies.